The story of women's rights is as old as civilization itself. Across continents and centuries, laws have sought to define a woman's place within family, society, and the wider world. Two traditions, Shariah law, rooted in divine revelation, and common law, shaped by centuries of precedent, stand as towering examples of how differently societies approach the same questions. Shariah law is derived from the Quran and Sunnah and customs of culture binding not only individuals but entire communities to divine principles. It is stable, unchanging, interpreted through centuries of scholarship. By contrast, common law emerged in medieval England. It was pragmatic, case-driven, and gradually expanded by statutes. It evolves as society changes, reflecting transforming values of freedom and equality. These two systems, one divine, one man-made, create distinct foundations for women's rights. In Shariah, marriage, or nikah, is a sacred contract. Women must give free consent. The Quran explicitly forbids forced unions. Brides are entitled to a dower called mahar that ensures financial independence. Yet in practice, culture often complicates scripture. Guardians, traditions, and societal expectations sometimes overshadow a woman's choice. Under common law and customs of culture, a different story was been told. For centuries, women were considered legally absorbed into their husbands through coverture. They had no property rights, no separate legal identity. Marriage was not a partnership of equals, but a hierarchy. Later, the Married Women's Property Acts of the 19th century changed this, finally recognizing women as legal persons in their own right, not subject to anybody's obedience. Sharia recognizes multiple avenues for divorce: talaq by the husband, khul initiated by the wife, and fasq granted by a court. Although imbalance remains, women were historically given more avenues to exit a marriage than under English law. Under common law, in England, divorce was nearly impossible until 1857, when Parliament introduced a series of Reform Acts that brought equality. Before then, women suffered most, bound by stricter rules than men. The 20th century marked transformation. From the Divorce Reform Act of 1969 to today's no-fault divorce laws, common law has embraced a model of equality and personal choice. Under Sharia law, women could own and keep property long before their European counterparts. A woman's earnings are hers alone, untouched by her husband's obligations. Yet, inheritance often grants women only half the share of men, reflecting complementary roles within the family. Common law denied women even this. For centuries, their wages and property automatically belonged to their husbands. After a long series of fight for suffrage, including the Equality Act of 2010, women could finally enshrine true economic independence. Adultery or zina is one of the gravest offenses in Sharia. With punishments ranging from flogging to stoning, the severity underscores its status as a crime against God and society. Yet the high burden of proof makes actual convictions rare. Common law once treated adultery as grounds for civil claims or annulment, but today it carries no criminal weight. It remains only as a reason, sometimes even a fading one, for divorce. Here lies a profound philosophical split: collective morality versus personal choice. The sexual revolution of the 20th century brought pornography into the mainstream. From glossy magazines to streaming websites, the industry flourished. Centered in the West, but reaching every corner of the globe. However, the dark secret of the emerging industry is the abuse of women, where trafficked women are forced to work under harmful conditions with no protection. Studies show lasting harm, psychological, physical, and social. Shariah law bans pornography outright. Its production, distribution, and consumption are deemed immoral, corrosive to family and community. Common law, however, regulates rather than prohibits. This reflects the larger divide: prohibition for collective protection versus freedom for individual autonomy. Few issues reveal the philosophical divide between Shariah law and common law more starkly than matters of health and sexuality. Under Shariah, abortion is permissible only under strict conditions to save the mother's life or within 120 days of pregnancy before the point of ensoulment. Beyond this, it is considered a form of infanticide, an act against God's gift of life. In common law, the liberalization of abortion in the 20th century marked a turning point. The Abortion Act of 1967 in the United Kingdom enshrined women's right to choose, later extended in 1990. This shift emphasized autonomy, the belief that reproductive choices belong to the individual woman, not the state, and not religion. Yet reproductive freedom comes with consequences. In Western societies, rates of sexually transmitted diseases have soared, fueled by casual sex, permissive cultures, and the influence of pornography. The late 20th century brought an unforgettable crisis. The HIV/AIDS epidemic devastated millions, exposing the dangers of unregulated sexual behavior and shaking governments, health systems, and families to their core. By contrast, Shariah law, through its prohibition of extramarital sex and its emphasis on chastity, seeks to prevent such risks altogether. Critics argue that such restrictions are unrealistic in today's interconnected world. Yet evidence suggests that conservative sexual norms in some Muslim-majority settings are associated with lower rates of infection. Here, the divide is clear: freedom with risk or restraint with protection. The global crisis of human trafficking connects directly to sexual exploitation. Across Europe and North America, women and children are trafficked for prostitution and pornography. In the West, laws attempt to regulate sex work and criminalize coercion. Yet enforcement often falters, and the thin line between consent and exploitation is easily blurred. Shariah law takes an uncompromising stance. Trafficking and prostitution violate human dignity and are strictly prohibited. For Islamic systems, there is no gray area. The act itself is inherently destructive, both to the individual and to society. From abortion to sexual health to trafficking, the contrasts between Shariah and common law highlight a fundamental tension. Shariah places morality and prevention at the center, framing sexuality as a collective responsibility. Common law, rooted in autonomy, accepts the risks of freedom as the price of individual choice. The result is two paths, one emphasizing protection, the other emphasizing liberty, each carrying consequences for the lives of women. At their heart, the differences are philosophical. Shariah draws from divine revelation, binding morality to collective responsibility, whereas common law adapts with society, centering on autonomy, choice, and secular freedoms. The future of women's rights will continue to navigate these tensions. Western systems will grapple with regulating pornography, abortion, and workplace equality. Shariah societies will continue to defend prohibitionist approaches, emphasizing family and community stability. Can these systems ever reconcile? Or will they remain parallel, each offering protections, yet exposing vulnerabilities? In conclusion, two systems, two visions of justice. Shariah, grounded in faith, emphasizing protection through prohibition. and common law, rooted in human precedent, advancing rights through reform and autonomy. For women, these frameworks shape daily life: the right to marry or divorce, to work, to choose, to be free. Yet the internalized patriarchy makes the choice difficult and unfair. The struggle for balance between protection and freedom, morality and autonomy, remains unfinished. As societies evolve, one truth endures: women's rights are not just about law, they are about dignity, equality, and humanity itself.